Everybody's getting their reminders.
Yep, should be. We are live now, so waiting for the screen to show up, then we'll be ready to go.
See what happens when I look down at this piece of paper.
One of the best ways for directors to understand what actors need is to just act. You'll be humbled.
Oh, turn that off. Hey everybody, this is Johnny here with MDI. We've been doing this weekly interview with filmmakers, local filmmakers, and potentially in the future we do with other state filmmakers. Today we got fortunate enough to have one of my best friend, Mary Ellen Tomazic. She was one of my attorney that I go to since 1998. She's been helping me since 1998 for every feature film, the short films, agreements and paperwork, all the waivers, everything else. I always had her to go through them with me. But instead of me talking this way, Mary, would you mind to tell everybody your name, what you do, and your background a little bit, so we can get it started?
Sure. I have been working with Johnny since 1998. Legal issues in filmmaking, also with a lot of musicians before that. So I do a lot of work with copyright, trademark, and music licensing and things like that. Just to say that there's a lot of traction around music in films and whether you can use certain things and stuff. And that's been a lot of the bad news that I've had to give people. But you filmmakers, Johnny and everybody wants to do it the right way. So that's why I've been letting them know how to do those things and not to get into any of the myths of copyright that are still around to this day.
Definitely. I believe you also did a couple of those lecture with the Indie Gathering and the Horror Hotel about copyright, intellectual property. And you also have a website that I think you need to update that pretty soon, right?
Yeah, that's, I have a new article that I'm going to put up there about terms and conditions. There's been some cases around it lately, and I've had some clients. Amazing what you find in certain websites of song distributors and people like that. So there'll soon be a new article about that.
Great.
You're right. I have not. I always tell people to go there and read the basics. Read the stuff that I've written over the years.
Yeah, I was there to check out your website a couple of days ago when I was putting together your information. I had to do my homework too.
Well, Johnny Woo set up my website, full disclosures.
I started the beginning part. You did the rest of it, so it's good. So for everybody who's watching right now, we actually have it on YouTube and Facebook today. The little glitch we've happened last week, I got to figure out how to do it, so we're doing it right. On YouTube, we have about 6 people, and on Facebook, we have 4 people so far. And of course, anybody who watching this, if you have any question, go ahead, type it in right away, just because if there's a 20-30 seconds delay, and that means that we don't see it until later. And so when Mary herself can talk about the different rules and stuff going on, then I can read the question and go down. So we have Wayne also here, Wayne, Nick Mobach, Ron, a couple other people there. On Facebook, we have 5 people, so I don't know who they are yet.
Hi, everybody.
Wayne was making fun of me because earlier I talked to him about his tie. He was wearing a tie that he was a little crooked. So that's it. He said it's an asymmetric tie off. So way to tie it up. So that's fine. So Mary, you want to tell us a little bit about what's going on right now? Do you want me to run the PowerPoint yet, or?
No. There's been quite a few updates in copyright law in the courts the last couple of years. I just mentioned a few of them. If you're just put this in the last year, there's been some very important Supreme Court cases about registration of copyrights. This came through last year, and it resolved a split in the circuit courts of appeal about whether you have to actually have the registration in hand in order to sue someone for copyrighted infringement, or whether you can just apply for it and say, kind of like application pending. Well, the Supreme Court, including some of the new members, have interpreted that to mean that you have to have the registration in hand. You have to have had the Copyright Office act upon your application. I mean, you could apply to something and have it be rejected. You don't know. So they require you to come into court with your registration now, and you can't just go and sue somebody until you have registered. So the best way to protect your copyrighted material right now is to actually go and get a registration for your material, whether it be a book, musical number, or CD, or even the sheet music and lyrics for it. They all go on different types of forms, but it's a pretty easy process over there at the Copyright Office website.
This is the copyrighted website, the Library of Congress, right?
Yes.
Okay.
And the Library of Congress takes in all the deposit copies, but they only put certain ones into the actual collection of the Library of Congress that they, list as what American works that they have. And it was very gratifying to see recently that a punk rock documentary called The Decline of the Western Civilization by Penelope Spheris was selected as one of the movies to go into the permanent collection. So there's hope for our punk rock documentaries too. But everybody, it's not that expensive. Copyright applications are about under $50 online. So
I think, yeah, well, for my feature film was $55.
55, sorry, 55.
Yeah. And then I had to do the feature and the script because apparently sometimes people can copy your script idea or wording. Yep. Yeah, so I had to do both of them. So that came out about $110 in total for me.
And that way you can protect the underlying material in case you want to make a new movie from it. Nobody else can make a movie from it. You can license it to somebody, as you know, to do that. So rather than waiting around for somebody to sue you and then having to go and register your copyright and then come back and wait around for it to be done, you can't go into court now unless you have that registration. So that's one of the big cases that came up.
So what about WGA? Some people say that they can register their script with the Writers Guild of America. It should be enough. And I believe that's not true anymore, right?
That would not give them copyright protection, but they can certainly register it for future use to prove that they wrote it and to prove that they own it. Interestingly, Johnny, I had told you just before that I was going through all the contracts and all the clauses that I had to see how many of them had stuff about pandemics or, epidemics or anything like that. And not too many of them do. And interestingly, the WGA agreement has nothing in it in their force majeure clause about an epidemic or a pandemic. I think because the writers are working at home. I don't think they need to go out, but
probably
very, very serious problem for theatrical productions and even trying to run your film in a theater. A lot of them had this clause here talking about the suspension of the film if it forces companies to because of the closing of substantially all the theaters in the United States for any of the above reasons or other causes which would excuse performance. I find it interesting that about 4 contracts had that clause in there. So basically anything where you're shooting a movie and anything that's going on now, as you can see, they're not able to continue with certain productions. And so I would imagine that some of their stuff is suspended right now.
Yeah.
As far as, because every theater in the country is closed. Yeah. Every theater. So I found that interesting. Not too much epidemic or pandemic clause language, but a lot about the theaters closing.
We got a question here from Scott Morrison. He's a photographer. So he asking about this about still photography. Does he have to copyright every photo he takes?
To sue someone, you do, yes. If you have a collection of photos that you send in by itself for copyright protection, and it's like a book, you will not be able to get the same amount of damages for that book. In other words, if your photograph is only 1/100th of the book, you're going to get 1/100th of whatever damages you would have gotten. It's a kind of a technical thing. A case came up about that with tattoo drawings. People were, they had hundreds and hundreds of tattoo designs, and they were registering them in books, and 3 or 4 of them got infringed. The thing with photographs is, Scott, there was just a case that came down about Instagram. Instagram has a feature where you can embed, the contract with Instagram is, if you have a public account, anybody else who has an account with Instagram can, under their rules and the way they do it, take and embed any photograph on the Instagram account into their account without having anything to be paid. This came up because this news place, Mashable, tried to buy a photograph from somebody on Instagram who had they were promoting under a public account, and they refused them. They were only offering a certain amount of money, and they wanted more, I guess. So this person used the rules that are on Instagram. I'm going to read this from here because I don't know what it is, but Johnny, you probably know what it is. With the use of Instagram's API, application programming interface, if you use that to embed it in your own, you can have anything that's on Instagram on a public account. This is because anybody that runs a public account automatically gives Instagram a non-exclusive license, and they're able to sub-license to other people off of that license. This happens with a lot of these contracts that are on the internet.
So
Scott,
does that mean Facebook is the same thing too, right? With the Facebook?
Oh, sure. I mean, I'm not sure what their procedure is. This case was about Instagram.
Yeah,
Instagram is owned by
Facebook.
Facebook, the same people, so probably the same thing. But there's a little bit of Instagram type situation with the embedding and it being all pictures. So this photographer then went and made her site private so nobody else could take and embed any more photographs from her site. But then again, obviously she can't promote with that. So Scott, watch what you put on Instagram. And yes, if you want an individual photograph to be obtain copyright protection, you must register it by itself.
Interesting. So we got 2 more questions here. One from Ron George. Mike, saying hi to you too. Mike Randini, he's joining. Ron asked this question: if you are making a film, can you reference a professional sport team? Example, can you say we were at the Browns game last night as part of the dialogue in this film?
This is an instance where I actually, on my website, Johnny, there's an article about that. That is a trademark situation where you're trying to refer to something that's an actual thing. Like you're walking down the street and you see a Volkswagen. You're referring to the Chicago Bulls. That's actually the example that I gave in my article. That is called nominative use. As long as you're not constantly referring to the Browns or the particular place or, showing their logo all the time or something. If it's in a passing reference, that is nominative use, and it should not be any kind of, that would be a trademark violation. That would be a Lanham Act violation. But any kind of small reference like that, as long as you're not focusing on it. I give the example of Wayne's World. If you notice, they always met at the hot hamburger place, never showed the name of it, never referenced any kind of major place like that. It's too expensive to do, and they might not want to be in your movie.
So it's probably better to be safe to not to mention a fake Browns stadium. Don't say Browns stadium, but say another game.
Or don't put it in your trailer. Yeah, out of an abundance of caution, we just were talking about something else. And
Right.
like, where were you last night? Oh, I was at the Browns game. And then you continue on talking about something else.
That
I
should
don't
be
think
okay.
there's anything wrong with that. If it's set in Cleveland, for example, or if you're out of town, you're like, oh, I had to catch a Browns game because we're in Miami or whatever, you know. But just like a passing reference like that. Same thing. The first panel I was ever on with you guys, Johnny, was Peter John Ross, the director, and his question and his issue was, what about logos in your film as you're driving down the street and you see certain logos? Same thing. Just don't focus on them. Don't put them in your trailer. Don't put them in your advertising. Nothing like that. If it's just a part of natural life, you can do that. That was just actually cited in the newest shutdown of the tattoo case, which I discussed a little bit on Facebook today. The court doubled and tripled down on them and said that any kind of image on a basketball player's personal self shows the reality and the realness of walking by the guy, or, you know, showing his actual persona. And so that is also nominative use. Just don't focus on it and everything. It's now, you know, not Supreme Court law, but federal law that.
And what about if I like holding a bottle like this with a brand name? So I should probably hide them instead then, right? Even
yeah, the best thing. I mean, the thing is, people want to get, oh, if I show this, I'll get, you know, it'll be I'll get a placement and then I'll get money for that. Well, that doesn't necessarily happen, as we know.
and
Any kind of national brands, you
like
don't want to get the, pardon me?
Like movie posters. You have background movie poster of Hollywood films. Are they be okay? Like you have a bedroom of teenagers and you have a bunch of different posters on the wall.
Mm-hmm.
That should be okay.
And that's your poster?
No, they're Hollywood movies.
I'm saying, don't use that in your poster. Don't use it in your, if you're just coming into a guy's bedroom and it has that randomly, that's another thing, would be nominative use. Now, if the whole movie was about, oh, I fell in love with this poster, Cheryl Tiegs, I'm aging myself saying that, but, you know, and I, you know, but, you know, the Who made a song about it once, but Pictures of Lily. But I think as long as you don't concentrate on anything like that, you're going to be all right.
Okay. We got another question here from Rolling Stop Film. Can you use popular song in your film if you're singing it with karaoke?
No, I wouldn't do that, because what you're talking about is the karaoke has a separate license for whatever they are. And that's been a subject of a bunch of cases too. Karaoke makers had to really alter things a lot over it's probably in the 80s and 90s, these cases came out. Anything that you have with any kind of tune that belongs to somebody else and you synchronize it with the film, that's a totally separate copyright move. That's a separate exploitation from, you know, putting it out. When you're syncing it with a film, that's different from making a recording of it. You know, it's just another thing that only the copyright owner is allowed to do. So what you do is you go and you sing your tune, you do your karaoke tune, and then you go and notify the owner of the tune that you are doing a cover version, and then you notify the Copyright Office, and the Copyright Royalty Board pays and collects the money from that to pay the owner 9.1 cents per copy or per play. So that's how they get around stuff like that. You even see in big movies where you hear a song and it's not exactly the original, it's almost it. Yeah, that's what they've done. They don't want to pay, or they weren't allowed to use that for the movie. That's a negotiated use.
So I have a complicated, well, before I go to the complicated question by John Sweeney, we have this question. It's similar to the copyright issue about logos and stuff. He says, for wardrobe in film, we sometimes cover logo or do not wear logo. Is that necessary? What is threat of wearing a Nike logo shirt, just clothing, not focusing but can be seen on the actor?
Well, you can take your chances and show that in there. That actually, people think of that because you remember all the rap videos that had all the logos pixelated out because either they didn't want to pay to have those used in the film, and the people just said, screw it, then we're not going to put it in there. Or I'm just guessing. Um, Again, if you have somebody going around all the time with a Nike shirt on, there's already been a movie based on Nike products. It's called Bend It Like Beckham, and it was partially sponsored by Nike. And I use that as one of my examples too, because the two girls were constantly into, you know, doing stuff like Beckham and you know, the soccer star, and um, they had a lot of Nike material in that movie. So um, that is something that the big companies have a lot of software to find stuff like that.
Right.
And rather than having to take it out of your entire movie, it's better to just, you know, and don't try to sit there and parody stuff either. That sometimes works, but sometimes it could be seen as disparaging.
Yeah. So I do know that most filmmakers, if you do have like person wearing Nike or any certain logos, but you didn't get permission for it, you can actually obtain the called error or error and omission insurance. It's thousands of dollars to pay for that, and that basically covering your entire movie from any copyright infringement that may arise.
Right. But first, Johnny, don't forget, you have to first get a clearance report that details every single solitary thing in your movie that could be copyrightable or trademark material.
Right.
And believe me, that will be found immediately and be told to take it out.
Yeah.
You can't, you know, errors and omissions insurance will not pay for stuff you do purposely in there. You know, you got to take out as much as you can first.
Right. Yeah.
And I mean, I had a client where the clearance report clearly said, and all this stuff is, you know, copyrighted material. You really, you know, logos, and they had all kinds of, they had music, and they had Metallica's Call of Cthulhu, and it was off their second album. And I'm thinking to myself, are they thinking that, you know, this is too long ago that this came out? And I told them, no, you can't use that. So that kind of stuff will be caught immediately.
So speaking of that, that actually got a good leeway to John Sweeney question. He wants to know, could you explain about public domain with respect to parody and satire, and also fair use?
Okay, public domain is something that's not covered under copyright protection anymore, either because it's too old, and the years just changed this year, or the end of last year, from public domain material out of copyright protection being 1924 and before. Anything made in 1924 or before is now out of copyright protection. As far as fair use goes and parody, there's a number of good cases about that. The biggest case on it is the Two Live Crew case, where they used part of Roy Orbison's Pretty Woman on their tune. And the crux of that was to the Supreme Court that they used only enough to suggest the tune. Most of it was their own material and lyrics. They had the, you know, like the hook line and a Pretty Woman, and then they had their own lyrics, which criticized and commented on the state of the situation when the original song was written. In other words, Roy Orbison was talking about a woman walking down the street in very, you know, flowery manner. Oh, I wish I could meet her. She looks so nice and everything. Two Live Crew took that and said, basically, here's a hoe walking down the street. You know, look at her outfit and stuff. And basically that's, you know, the entire lyrics are in the Supreme Court case. It was in 1992. So if anybody wants to look that up, they could get a good laugh out of seeing all Two Live Crew lyrics. But I got the impression that the court enjoyed it. But the point is that that was hashed out in court, as are all fair use cases. Fair use is not something you can just declare. That is something where there are 4 different aspects to it. And, you know, a lot of them have to do with whether they're the amount and substantiality of the piece that you took, what you did to it to make it transformative, if anything. and comment and criticism on it. That's why a lot of documentaries and educational use is fair use, because it's done for educational purposes and comment and criticism on the actual lyrics. You know what I'm saying? Like, there's a couple cases where they tried to say, oh no, we're just doing a parody of, Dr. Seuss, but it had nothing to do with Dr. Seuss. You know what I mean? They weren't commenting or criticizing. They were just making funny Dr. Seuss stuff. So to sum that up, fair use is not something that's easy to have declared. You get sued, and then somebody, you give your proofs as to why this is fair use, because it's a parody, it's commenting or criticizing the actual, work that you're taking. You don't use too much of it, just enough to suggest it. And whether it's for commercial or for nonprofit use, that's another factor for you to think about.
Interesting. So Tyler got in a little bit late, so he's asking about copyright films. Is it important to copyright your films you are sending to film festival, and how do you do that?
It's probably a good idea, because you can't sue anybody for taking your film or appropriating your film or using parts of it or anything like that, unless you have a copyright registration.
So it's always important before you send to the festival.
That it's probably a good idea. Probably a good idea. I mean, your timing of how long it takes for you to receive the registration might be dependent on that. Now, let's not forget, Johnny, sorry, I didn't mean to cut you off there.
Sure.
If you're going to a film festival, you want to do what? Sell your film, am I right? And hopefully. What do you have to do to sell what do you usually have to do to sell the film?
You have to register everything and you get everything together.
And you have to transfer the copyright in the film.
Right.
So if you don't have the copyright in the film, you can't transfer it. So you're up there saying, like, I can sell you this film in about maybe 3 months by the time I get my copyright. It's best to have all your ducks in a row, I would think. You know the other aspects of it, but I'm thinking I would go into one of those film festivals, not only with, a finished product, but a registration for it.
So this is for short film too, or you preferable for feature? Because short film, there'll be a lot of paperwork to fill out there, right?
Any film, any motion picture, even a real small amount.
Just to let you guys know, the registration time frame, when you register, you had to submit a copy of your movie, finished movie, so they have a record of that. It takes about 6 to almost a year before you get your paperwork.
That is true. You can get a expedited registration, but it costs like $800.
But they do say that if you have the confirmation number from them when you submit it with a movie, that can be used for
right. That would show. Yeah, for those purposes, that would be fine.
Yeah.
Look, we've got our application in, it's pending. So far nobody's, I mean, a trademark is a little tougher because you publish it for opposition, and then somebody comes in if you've infringed anybody or anything like that.
Cool. All right, Wayne got another question for you. This is kind of related to the one he just asked earlier. Film sets can be created with new items. Cars have logo, clothes have logo, drinks have logo. How does indie filmmaker get around all these dangers and still have a realistic set?
It's not easy making films, is it, Johnny? I know.
I know for a fact, every time we have to have bottled water on set, we have to get rid of the logos. And
it's just, there's a number of set dressing cases as well. One of the most famous ones is also in my materials on my website. Ringgold is a lady who made a quilt, and she made it for her church. And the church used it as a fundraiser and made posters of it. Well, one of these posters ended up in the set of the television show ROC, if you recall. It was on in the 90s. And they never credited her, asked for permission, or did anything like that. The poster was like in the same kind of setting as a church. Now the church was losing money off of that. The church was really they were exploiting, the lady gave it to the church to exploit. But she then saw it on an episode of ROC, which was in reruns, and said, wait a minute, I didn't even get credited for that. She sued them and won. So set dressing is important. Another case with you may ask next, like, well, what if you can't see it that well in the picture? What if it's just blurry? Okay, then you're in better shape. There was a movie where there were seven, not the movie Seven, that was another copyright case, where there were art prints on the wall, and they were kind of vague. They were kind of in the background. They weren't. They were kind of not really that noticeable. Well, the artist noticed them. He knew what they were, and he went and sued the movie company. But meanwhile, the standard is an average person, would they recognize that it was that guy's art up there?
And
So
that's such a very good point. Yeah.
yeah, if you've got it in the background, if it's not really that noticeable. There's another one. Some of the graffiti art cases are like that.
Graffiti.
They have a combination of nominative use, just walking down the street, or being kind of faded in the background rather than up front. And
Right.
so that kind of thing really makes a difference. And a lot of people have litigated that type of thing.
Yeah.
If you remember the movie Repo Man, they had the generic beer cans. And, actually, that was actually a product, but it was kind of a goof to show, they weren't going to be paying any big beer companies, or
Wow.
beer companies didn't want to be in Repo Man with all the punk rockers, probably, right? So.
Yeah, I totally echo that sentiment about watching your set, because like when we did the feature film in itself, we wanted to have a room with posters, so we had to use our own movie posters, and then we had to use our own movie videos on TV set, so it looks like they're watching a show or something.
Right.
We had to get rid of the logos. We had to make sure there's no label scene. It's lots of things had to be done to make sure that we don't have to cut.
Because there's TV background.
Exactly.
Cases, so
everything had to be done that way.
yeah.
So in related to that note, what about cosplay? Let's say you making a movie, and you decide to make a movie at a Comic-Con, and people are dressing up with like a Deadpool, Spider-Man, or Thor, or whatever. So how would that be a problem, because they're cosplaying the actual characters? Would that be a problem when they have that in the movie?
That comes right into another Supreme Court case. As you know, we talked about this on our panel. Cosplay is a creative venture of people, and in the Supreme Court case, it was actually about two uniform making companies.
That's right. I remember that one.
Who were trying to, one was suing the other one for the designs. And, it was just the cut and the chevrons of the cheerleader costumes. There was no real pictures on it at all or anything. So they had to decide what is copyrightable as far as it works. What is the lowest level? Because it is a low bar for copyright. Anything with any kind of originality is copyrightable. So in the case, Varsity Brands case, a lot of people brought in amicus curiae briefs. In other words, and cosplay people brought those in, a number of people. Also people who are sewers, they sewed costumes and everything, to argue that there should be some copyright protection for fashions and costumes and things like that. That's been tried. There's been like over 70 bills in the legislature to try to protect fashion. Never has it been done. The competition and that is really what does it. Okay, as far as Comic-Con goes, a lot of those costumes have, or a lot of those Comic-Cons have big costume contests where they are winning money for their costumes. When you make money off of another person's logo, even though you have made it into a costume of your own, that's going to be problematic. And some of the cosplay amicus curiae brief people were discussing that as well. In my view, when you have something that is just the cut and form of the uniform, or there was a big cosplay uniform. There was a group that that had actually the permission from the author to make costumes for this particular, a book that they liked. But what you want to do is make it so anything that's, according to the Supreme Court case, anything that's able to be taken off the costume and put on a straight piece of paper and be copyrightable, that you don't want on your uniform unless you own it. In other words, you don't want, Star Trek logos and things like that. A lot of the characters are copyrighted. You mentioned Spider-Man.
Right.
That character is copyrighted as a character. So is Batman. So is the Batmobile. There was just a case about whether you could get to the level of being copyrightable as a character. What has to happen? It has to, be it has to show as the same type of person each time. It has to have the same characteristics each time, stuff like that. Cosplay people, they kind of half won and kind of half lost on that case, because you can make any kind of form you want as long as it's not protectable by copyright. That's kind of a weird way of putting it, but like if it's not the entire character, like you can't get in there with R2-D2 or anything, you know what I mean? You can't do that. But maybe you would have a similar cape or something like that,
Okay.
of somebody in Star Trek or one of those deals.
Gotcha. So Pauline got a question here. Hi, Pauline. She asked us on Facebook. Can you use news footage in your film?
Of course, that news footage is all copyrighted. What you want to do is, if you're trying to show a certain period of time or a certain, the classic thing is somebody's kidnapped. Here's today's newspaper. You're listening on the television. Oh, Germany just invaded the Netherlands. Old time stuff like that. I'd still try to make it so it was minimal. And so it was just a hint of what you were trying to portray. What are you trying to portray? You're trying to say it's in the 1940s? Do you have a television that looks like that? Are you trying to say it's in the 60s and the Cuban Missile Crisis is going on? Are you trying to show, and I haven't seen that movie yet, but are you trying to show footage of the Waco situation in Texas?
Right.
The more you use, the more the news service is going to go after you.
Aren't this footage sometimes our public domain?
No.
Okay.
The photographs are all copyrighted. The news itself is, I wouldn't characterize it as saying it's in the public domain, but anybody can go to the news, the thing that's making news. You can go to the car crash. You make your own news. You can take your own pictures. Yeah, that's right out for everybody. Anybody can go there and do that. But once somebody does that, you got a copyrighted work. Gotcha. And as you know, a lot of these photographs are then licensed to Getty Images. It's the amount and substantiality of what you're using, right, that makes the real difference. All you can always ask for permission. It's not beyond the pale that might happen.
Yeah. So we have more questions now. This is a non-stop question, asking you a question, which is kind of good. Rolling Stop Films. I don't even know who you guys are, but thank you for asking all the question. This is a good one too. Can you show a tattoo of a famous logo such as the Playboy Bunny?
No. People's tattoos, I said this tattoo case just came to a close. But for you movie buffs, you might remember that movie, Wedding Crashers. No, not Wedding Crashers. What was the other one about the
Time Machine?
No. The before the wedding thing. Oh shoot. Anyway, the movie had Mike Tyson in it with his tattoo, right? And then all of a sudden the guy in the movie, the other actor, ended up with that same tattoo or very, very similar, the exact same thing on his face. What is the name of that where the best man has the thing for the guy the night before?
I can't remember it now.
It's slipping my mind. But anyway, they got sued for that. And
Wow.
they did not ask permission to do that or anything like that. And the fact that the Mike Tyson had it was what made it famous. And so, you know, if they had just gone and gotten, you know, one, and I think it was like not exactly the same, it was similar. What is the name of that thing? Anyway, there were two of them. Hangover. No.
Oh, the Hangover 2.
Yeah,
Okay.
that's it. Yeah. So if you look at that, they got sued for that.
Games Girls also mentioned that also right now. Hangover.
Yeah, and Cardi B also had a copyright case about a tattoo picture of a guy with a tattoo on his back that she used on her album. And the guy that had the actual tattoo sued her because she actually CGI'd it onto something or whatever, but it was the actual tattoo on the guy's back. And it wasn't the actual guy, but it was his tattoo. Query, who owned that tattoo? You know? So that's the first thing you got to figure out is who owns the tattoo. In a situation where I have a famous artist friend, Derek Hess, who has a lot of people put his art on themselves as tattoos. He is okay with it. In fact, he went and got pictures of them all, made a book of it, and sold the book. So there you go. Playboy, that's a very famous trademark. As long as you're not using it for anything except putting it on yourself, that's fine. But if you're going to be in a movie where the guy with the Playboy tattoo, no, that will not work. You know what I mean?
Yeah, true.
He just goes by and he has it on there, you know.
I got three more questions here too. Funny thing. Pauline have a follow-up question about the news media article, news footage. She said, "What about if she make it as a collage of news footage put together? Does it still copyrighted? So like she go to every media and grab all the news footage and combine them together."
You're going for trying to make it a transformative use, and that may or may not happen. That's probably a better way. Let's not make it a half hour long either. Let's make it really quick. You know what I mean? What are you trying to do? Are you trying to make your movie better because you're using somebody else's material? Is that your point? Or are you just trying to portray that, oh my God, this stuff happens so fast. Look at this, or if you go like this, Rip Van Winkle, he woke up and all this stuff and immediately all this stuff speeding by, or if like, oh my God, everybody had this story on their, platform or their news thing, and then showing them all real quick, to point out that, oh my God, everybody knew about my thing, whatever. It depends on what you're using it for. The purpose and substantiality of the use.
All right, we got a lot more questions coming in because of tattoo question from earlier. Ken Mobach asked this question: who owns the art, the tattoo artist or the person who with the tattoo?
Depends on what kind of deal you make with it. In the case of the NBA players, they sometimes the tattoo artist will have them sign releases that they still retain the copyright to it, because if they want to put it on somebody else. If it's a custom one, like one was put on LeBron James by the tattoo artist in the case that I referenced, Solid Oak Sketches, versus NBA 2K. That was retained by the artist, and I guess LeBron James had no problem with him using it. Now, sometimes the person that is getting the tattoo will come in with something. Here, I want this put on. Well, obviously, the tattoo artist doesn't necessarily own it then. In that case, you probably make some kind of a disclaimer or release by the tattoo artist that, for example, Derek Hess. I said to Derek, these tattoo guys, do they have your pictures sitting up on their wall? He said, no, nothing like that. The people bring them in. So that's kind of a loose thing that's allowed evidently by some artists. I'm not saying all of them, and his art having to do with trademarks.
Oh, okay.
So
got more question here. Tyler asked this question, which are kind of funny. What about nude footage?
As you may know, the SAG contracts have provisions where the actors or actresses may agree or not agree to be nude in certain scenes. So that is a thing. It impacts your movie in that you're going to maybe run up against the obscenity laws. You're going to maybe run up against not being able to sell it to people because they don't want
Nudity.
nudity. You may run up against, if you have a product in there or somebody else in the movie, they don't want the product being associated with it, or they don't want to be in the movie. So it depends on how that works. Now, I just recently saw a film with nudes in it, Robert Banks film, and some of the people nude in it were people we know. It was artistically done, and I didn't think it detracted from the movie, which was kind of a surrealistic. Johnny, I'm not a film historian or anything, but that was. I guess it depends on how it's done, what the purpose is, and what kind of permissions you might have to get for nudity.
Very interesting. All right, this is a question from Wayne, and kind of talk about me. What is permissible in fan films? Johnny has made Superman, Spider-Man, Doctor Who film, and so it is okay. But others have gotten into trouble. What is okay and what is not okay?
Talk about Axonar. Yeah, that guy, he ruined it for everybody, didn't he?
Yeah, he did.
Yes, he did. Fan films are meant to be a tribute and an homage to the genre or the film or the particular character. Am I correct, Johnny?
Yeah.
And Johnny's done it in a very clever way where he never uses the actual name Superman. He suggests the logo, and still in all, he makes it into a fan film where he's not selling it. He's doing all the things that the big companies want you to do now, which now, you can do certain things and you can suggest certain things, but now you're restricted from doing Star Trek films, fan films to 5 minutes. They have restrictions on what kind of material you can use. We went over that in one of our Comic-Con panels, but it depends on. A fan film can't be shown commercially. A fan film can't be sold. A fan film is just, for your portfolio, right? To show what a great filmmaker you are doing this, that, and the other. And to show your love of that. And I thought the S4 film was excellent. I thought the Batman one, I didn't even know any of the people in it. I mean, it was so carefully done that you'd really have to be a buff to know certain things. Okay, I know Mr. Freeze, but there's restrictions to it now.
So things have to be different now too.
Yeah, I don't even know if you want to put it on YouTube or something.
Hey, Mary, you might want to turn the lights on a little bit because you're getting darker inside.
Pardon me. How's that?
Oh, better.
All right.
All right, Ron George, I have a question here. What about referencing a fictitious character in the film? Example, you are in a police station and they are interrogating a suspect. Can a police chief tell the officer to stop acting like Jack Brown?
I
think that should be okay.
You're saying the person that's interrogating is somebody that's known, or?
No, it's interrogating a person, and then the police chief tell the officer to stop acting like Jack Bauer. It's a fictitious character.
That's one of those nominative references,
The reference, okay. That should be okay.
I mean, how many times do you see references to famous actors or, Charlie Chan, you've got, W.C. Fields, what did he say? There's a sucker born every minute. You think people don't refer to that? I mean, there's ways to make little references that are like everyday life. and not trying to focus on a certain particular thing.
Yeah, yeah. So we got another 10 minutes and we're waiting for a question to come in. Do you have anything you want to tell everybody here too? Or the time is flying really fast right now.
Okay. What I had mentioned before was this is a very, very serious problem, in my opinion. I mentioned the Instagram case. The focus of the articles in the case about it was read your terms and conditions very carefully on the websites. That is usually where you find your obligations. I had a guy come to me who was distributing music on a certain distribution platform company. And he had emails back and forth and puffery and what they were going to do and this, that, and the other. And I said, well, where's your contract? What did you agree to do? How long is this term? And, oh, no, it's just these emails and stuff. So, of course, I went on the website. And sure enough, right under their terms and conditions, way down at the bottom where you can click those links, an 11-page contract. So, you have to look for stuff like that, people. You musicians, go into a place like CD Baby. CD Baby contract is really super long, but guess what it tells you? They can take anything that you give them and use it for anything. Your stuff, their stuff. They can put your picture on somebody else's account, anything they want to. They can use it for advertising. They can do anything they want. So I say, people, really be careful what you're reading and what you're signing for these things. Nobody does anything free. And you may lose the exclusivity of your material. And next time that record label comes along or that, movie company comes along and you find out, oh no, I did this on an exclusive basis for them. I can't use it anymore. That's what I would tell people to watch out for.
Yeah. That's a very good point. You and I talk about my current distributor for the future film, and it's a 6 years agreement. So I sent an email to the big boss. I said to him that I was concerned about all the things I hear outside of on Facebook, and he called me right away. We have about an hour conversation, and he agreed to he understand where my coming from, and he agreed to give me more quicker updates, more frequent updates. So we're going to talk once a month now, just because of the concern I have. At the same time, he said to me that he doesn't want to have any issue with me, and he would rather want to prove to me that he can sell my movie, which is good. I think it's a good thing that he really do. We're compromising each other, make it work.
Right. I mean, he didn't just go on the boilerplate terms of his contract, and he was willing to negotiate a little bit. I remember that contract was a 10-year term at first.
Yeah, it was originally 10 years, and then it came down to
that's
6
a long
years.
time.
Yeah, but then at the same time, I read all the different contract agreement from the past. It's almost the same thing. All the agreements the same issues. You want to sign a contract, you may have to follow the rules, but if the guy or the distributor are good enough, they can probably talk to you or compromise something with you. That's great.
Right. Also in those contracts, you got to watch, because they also most of the time say, we are not under any obligation to use your material or to show your movie or to, use it in our materials or whatever. Here in your case, they're selling it. So they're asking you like, hey, give us 6 years to sell this off, give us time to get it out and do our thing and all that.
Right.
You, instead of, really, going through maybe some boilerplate stuff that says we're not obligated to do anything, you made the guy obligate himself to it. So that really sounds like a good thing as far as.
Yeah, I'm very happy that he actually had a conversation. And
sometimes they don't even know. They don't even realize.
Yeah.
What these things are doing, or they would think it was okay,
Exactly. So it's not to hear them to be more proactive to work with me than just ignore me. So that's always good. We got a question here from Gang Strauss. How much of a public domain film can be used in a new film? Example, a character watches Plan 9 from outer space and sees event from the film in his real life and see the event happening in his real life.
That's not in public domain.
Plan 9 from
outer space?
Oh, that's not?
That's been renewed.
All right. So what about any public domain movie?
His example would be, Night of the Living Dead. That fell out of copyright in 1968 because they didn't put proper notice on it. That's not even required anymore.
Okay.
But if you go through, which I have gone through, a lot of the AIP pictures, American International Pictures, the the horror movies, those are owned by big entities now, like Sony and people like that have bought Warner Brothers, and there's a chain of custody for those that goes a ways. But the ones that fell into the public domain by not being renewed after 28 years are kind of well known. And like I said, anything before 1924 now, 1924 and before is all in the public domain. Now, another thing came through with legislation this past year, or actually in 2018, about the pre-1972 musical albums and songs, because recordings didn't used to have copyright protection. They were kind of in limbo for a while and being protected under state law, and just signed into law in 2018 was a protection for them that those 1972 and before recordings are now protected under the copyright law. So there's been situations where the copyright law has been adjusted in order to save certain films and musical recordings and stuff.
So you can relate to those public domain film and say that this happened to my life, or assimilate to that kind of an ordeal too, right?
Yeah, I mean, you can use anything in the public domain. You can't get a copyright on it. You can use it as part of your film, and you list it as a pre-existing material.
Gotcha. But you still copyright your movie?
It just can't be the subject of a copyright by itself.
Okay, got it. Okay.
I mean, whatever else you're putting in the film, obviously, that's what you're.
Right. Okay. But Pauline got this question, follow-up question. Is it okay to use a line in your film from another movie? Example, it's amazing what you would do when you don't believe in God. I don't remember what the movie was in. So she was basically trying to figure out whether or not she can use a line from another movie in her movie.
Individual titles and phrases are not copyrightable. If a person would go to the length of being the owner of the movie and then going after somebody for one line, actually just said not even taken from the film. If she had taken the clip from the film, you might have another question. I don't think that's a problem. I mean, we all quote stuff in regular life. Now, if she had a business having to do with this line, or if her whole thing was on this line, it's all on the focusing of it.
Right.
If it's just a passing reference, then you're just trying to give details of real life, in your movies, to make characters more in depth, so they're copyrightable, and people can't steal them. Ideas are not copyrightable. Well, you have to really flesh them out and put a lot of details in them.
Right.
So that helps with that.
So Wayne making a funny joke here. Who owns the copyright for this recording? YouTube, Facebook, Zoom, or Johnny or you?
That's a good question. Very good question.
So
it's being put out as a public service. It's kind of a not really a commercial venture here. I don't think that you're going to have a thing at the end saying, you should use MDI films for all your work of,
No, we don't do.
As far as I'm concerned, Johnny created it, and you can keep the copyright in it. How about that?
Look at that. Yeah.
Now look here, if he goes and what if Johnny went and you had like a whole bunch of your video chats that you created, whatever platform it's on doesn't matter. That's just that's just your platform. Whatever ones, what if you got them all together in a little video compilation box set and sold those? I don't think that would be a problem.
Huh.
I don't think that'd be a problem.
Now you give you great ideas.
I mean, because what is Peter John Ross in there? He has his program Frame Lines,
right,
and that's showing people how to do certain things. and explaining to people how films work and things like that. And I think it's for educational and, educational purposes. Right off the bat, you get fair use. So
That's pretty cool. Now I know that. So what about documentary? Documentary, can you use any, I mean, this is something that a lot of people ask me about. So that they make a documentary and they decide to use a news clip from Channel 3, or they use a copyrighted footage from somewhere. Are that legal, or what is the length you need to do before you become illegal?
documentaries are more protected under fair use. They have much more chance of being able to use other people's material and, take stuff and put it together and comment and criticize on whatever topic they have. If you had news footage about, let's say, some murder that happened in Cleveland or something like that, as they do on these programs that you see. My husband watches a lot of them. They have the footage, a little bit of maybe the initial story about it, but they don't concentrate on that. Often you'll see clips from news footage about that murder or Anthony Sowell or something like that, used in a documentary to help portray and comment on the incident. Again, you can't just take the whole program. I mean, these things have to be put together in a thoughtful manner and so that they are a transformative use. In other words, they're not a news program. They're used for a different purpose than the news program was used for. Okay. You're using it as a documentary on serial killers, let's say. Here's a clip from here, here's a clip from here. And then you have other people, you go and interview them. There's a lot of things that are put together with that. And I think they're, a traditional part of any kind of documentary, news footage, especially if it has to do with stuff in the news. So again, you'd have to look at your amount and substantiality, but don't forget, everybody, whatever you use, whatever you do, whether you ask permission or not, please credit everybody down to the last person. Credit everything. I mean, the Ringgold case, the woman said, if I'd seen my name on the screen, I would have been okay. If they had credited me, I wouldn't have sued them. Yeah. So it's always good to get permission or to make sure that you're crediting the photographer, the person, whoever it is.
Yeah, we are actually at the end of the time here. We have a last comment. This is his takeaway. He said, copyright is always confusing. His summary is, film is hard to avoid legal risk. And second is, fan film is okay if done right.
True. So, what do I always tell people, Johnny? Like, here I'm going to give you the bad news, how hard it is to get all these things together. It's hard enough just getting all these number of people together to make a film. It's more than a band, and bands have tremendous amount of problems. But then to get all the material that you have to go with it, it's a yeoman's job. And I tip my hat to all the filmmakers who are going through all this and navigating all these waters. I appreciate that.
Do you have a last advice for film everybody, or last comment?
Johnny, as you know, I'm on the side of the creators. I'm on the side of the people who own the works, and people who want to use their works in their work. I ask them one question: what if you made a film and somebody took a piece of that film and put it into their film, and they made $1 million on it, but they didn't credit or pay you? What would you do? Then they start to get, oh, that's right. What if and that is exactly what happens a lot of times. That is exactly what happens. And people have to realize they're creators and other people are creators. So they have to respect both ends.
Yeah.
Which is difficult. I get it.
It's always difficult, yes.
Yeah.
Well, thank you very much for being here with me and with a group of people. People really ask lots of questions. It's non-stop asking.
Well, thank you very much, Johnny. And thank you so much for everybody coming in and asking the questions. I really enjoyed it.
So if you guys can tune in next week, we are going to have Keith Collins II, which is a fight coordinator, a very good friend of mine, and helping me, and I'm helping him a lot of his feature films. So he'll be with me next Monday at 7 o'clock and join us and ask a question about fight and safety. See
The
you guys.
Black Belt twins. That's
Take
right.
care.